Morning. Thank you for attending today's Government Contractors Forum, two-session boot camp on the GC's role in bid proposals and protests. Our first panel is titled Adding Value to Your Company's Complex Proposals in Response to Government RFPs, brought to you by the ACC National Capital Region and Thompson Hine. My name is Matt Doss, and I will serve as the chapter's host and as a panelist for the presentation. Please note that today's program is being recorded. All web seminar participants should be able to receive the slide presentation as well as the audio over the web. If you run into any difficulties with the audio, please refresh your screen. Web seminar participants can queue up a question for us at any time during today's presentation. Simply type your question into the Q&A box on the right side of your screen and click Submit. All remarks made by the panelists in the session today are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC National Capital Region. And now it is my pleasure to introduce the panel. Joseph Berger is counsel in the government contracts and construction practice groups within Thompson Hine. He has extensive experience in the representation of government contractors in bid protests, litigation, investigations, False Claims Act cases, and contract compliance and regulatory matters. Joe's bid protest experience includes more than 75 protests before the U.S. Government Accountability Office, U.S. Court of Federal Claims, and executive agencies, winning favorable decisions on behalf of both protesters and awardees, securing corrective action by agencies, and working with agency and Department of Justice attorneys to defend awards. Chip Purcell, Jr. is a partner in the Thompson Hine Government Contracts Practice Group. He focuses his practice on all aspects of government contract law and litigation. Chip counsels clients on issues involving the formation and performance of government contracts and represents clients in pre- and post-award disputes involving the government, as well as prime contractors and subcontractors. Ray Mccann is senior counsel in the Government Contracts and Construction Group at Thompson Hine. He has broad and deep experience in federal government, international and commercial contract, and software licensing law. His extensive experience also encompasses litigation and litigation management, mergers and acquisitions, FOCI negation, antitrust, project financing, employment law, investigation, and ethics and environmental compliance. Ray has a top secret security clearance. Tom Mason is the leader of the firm's Government Contracts Practice Group. He focuses on his practice on all aspects of government contracts law and litigation, has extensive trial and appellate litigation experience with a broad background in commercial and government contracts litigation, including civil false claims, accounting and intellectual property issues, and bid protests. I am Matt Doss. I am General Counsel of Allied Associates International, a veteran-owned small business in Virginia, focusing on defense and intelligence communities. Thank you, everyone, for being here this morning. Let's begin.
All right, good morning. I'm Ray Mccann, and I'm going to first show you, here's our agenda for the first session, and I'm going to be talking about preparing for and responding to the substantive requirements of a solicitation. Just a little bit more background for me, although I'm with Thompson Hine. I've spent 26 years in-house at Hughes Aircraft, Raytheon, Quest Government Services, and CenturyLink, among other companies. So I have extensive proposal preparation experience. I've seen a lot, let's put it that way. I'm assuming that most of you have some proposal experience, but that you're not experts. If you were experts, you wouldn't be here. Or you wouldn't be on the webcast. But if you had no experience, then you probably don't understand how important it is for the in-house counsel and general counsels to be involved in all aspects of the preparation for responding to a solicitation and actually proposals reviews. So we're going to cover a lot of topics this morning at a fairly high level, but if you do have questions, of course, we'll be glad to entertain them. Not that we'll give you an answer. We may be like the government when you ask a question about a provision in an RFP. We'll just refer you back to the RFP, okay? All right, so first I'm going to talk about Blackhat reviews, and this is the first time that most attorneys in-house would become aware of an opportunity if they're involved in a Blackhat review. And this is part of the decision-making process for the company to decide whether or not to pursue an opportunity and what the likely challenges and strategies are going to be. What is a Blackhat review? It's a competitive assessment of potential competitors and their strengths and weaknesses. It usually precedes a bid, no bid decision, although some companies will combine the two, or they'll call it something different. And there's really no single way to do a Blackhat review. The two main points that I wanted to emphasize here as far as the role for General Counsel is first that a Blackhat review's only as good as the data that it's based upon. And so where you can help the process and make it a good, solid process is by asking questions. If you don't see that the data that is being discussed about your competitors or even internally about your own company's strengths and weaknesses is there, then you can ask questions and ask, basically get them to go back and get answers before the wrong decision is being made. And the second point is that a formal, consistent methodology like a SWOT analysis is I think, important in order to develop a good capture and proposal win strategy. And it will, I think, affect your teaming strategy, as we'll get into in a minute. And so I just end this slide with a question: should General Counsel be involved in Blackhat reviews? And I think the pros outweigh the cons here. The pros obviously are it helps you understand your company's business strategy and the goals, the importance of the opportunity. You will get early insights into potential risks in that pursuit of that opportunity and where legal support may be needed. For the cons, they do take a lot of time, and there may not be any legal issues present right away, and so you might be thinking, well, I'll get involved later. I don't think that that's the right way to go. I think getting involved in the very early stages of the opportunity review will pay dividends down the road. As part of your preparation for responding to solicitations, you may find that you need to identify and work with teammates, subcontractors, and vendors. A Blackhat review normally will include a gap analysis as part of the review of your company's internal strengths and weaknesses against an assessment of the customer solicitation requirements. You might find that you're weak or you don't have sufficient resources or they don't even exist in a particular area. And so you need to determine what you need in order to increase your probability of win. If there are any gaps, how can they be filled? You may need to get more internal resources or external, and we'll talk about the external more than internal, because even when you find that you have gaps, you may decide that you want to go outside anyway. This next slide shows a list of where gaps in meeting the customer's requirements may exist. I'm not going to go through this, but these are areas that I would say you'd want to ask questions about when that gap analysis is being conducted. This next slide addresses how to evaluate potential teammates to fulfill the gaps. And so I have some suggested criteria here for evaluating potential teammates. Again, I'm not going to go through all these. These are for your future reference. But there are things that you would want to ask about when you're discussing potential teammates amongst your team. As I said earlier, even if no gaps exist, you may want to team with other companies anyway, and we'll get to what I call the legitimate reasons to team on the next slide. I think the main thing here when you're doing your gap analysis is to make sure that the deciders, which may or may not include you, that they document their decision. This is important for two reasons. One is that you may find that you have to defend your decision later on, either internally when the big bosses say, you know, why the heck did you team with that company? They're terrible. That was a terrible decision. What made you even think that was a good decision? Or you may have to defend it against a challenge from the outside, from the government, for example. And the second reason is that it may help you in future proposal efforts as part of a lessons learned as to why you chose a particular teammate. This next slide shows what I think are the legitimate reasons to team. There's quite a few of them, obviously. The first one, I think, is probably the one that you really are going to be obviously focusing on. If you don't have the components or subsystems capabilities internally, you would certainly have to get them outside. Otherwise, you wouldn't be able to compete for the opportunity. Second, to present a stronger position to the customer. This, I think, is important, and I'll give you an illustration from my past. When I was with Quest Government Services back in 2005, 2006, we decided that we were going to compete for the networks program, the big GSA telecommunications program that's winding down now. At the time, Quest did not have a strong federal presence, and there were parts of the networks program that were pretty complicated that we just didn't have the internal capability. So we brought in some teammates like SAIC and others that I think made a very big impression on the GSA, especially during the first part of the discussions after we submitted our initial proposal, and they found out that we were really serious, that we were a serious competitor. And we ended up winning both slots on both the Universal and the Enterprise program. So we presented a very strong position to our customer as a result of teaming with companies like SAIC. Some other legitimate reasons include to further the state of the technical art, maybe to facilitate entry into an otherwise closed market. This may be important, especially in the international arena, where you would need a local teammate in order to have some legitimacy in front of the government there. To spread risk, financial risk or other risk, to decrease your costs of proposal preparation or contract performance. Those are pretty obvious. To create or capture or create or increase revenue. This may be the only way that you're able to win the business is by teaming, because you increase your win probability. Primes often will look at the breakdown of the work and keep the more high margin work for themselves and team with others who can perform more efficiently what they would otherwise consider to be low margin work. To affect geographical dispersion of business. Lockheed and Boeing, they are masters at this. They have anecdotally created teams that had facilities in all 435 congressional districts. Guess what that does? It gets them funding. It gets Congress to provide funding for their programs. Better customer service and support, and of course, the best utilization of your company's resources. I call this next slide illegitimate reasons to team. These are basically teaming for the wrong or for prohibited reasons. If what you hear in your Blackhat review or your gap analysis is that we're going to dominate the market, or we're going to take this company off the street so that we eliminate or reduce competition, that could be a problem. It could shut everybody else out, and that could be an antitrust violation. Same with controlling prices or profit percentages. Again, a potential antitrust issue. The last bullet there, to obtain the proprietary information of a competitor. I've seen this where a company would team with a subcontractor that was on a program that my company was on in order to try to get the subcontractor to provide our proprietary information to us surreptitiously, and that's not a good thing. Next slide basically summarizes the parts of FAR Subpart 9.6 that deals with teaming arrangements. I'm not going to go through these except for the last one, 9.604, which contains the limitations that are spelled out in the FAR. The FAR policy does not sanction, for example, the violation of antitrust statutes. Also, it does not eliminate the requirement to obtain consent to subcontracts by the contracting officer if you don't have an approved purchasing system. Contracting officer can still require that. Responsibility determinations. The government still is required to do a responsibility determination of the proposed prime. Data rights. Regardless of who's on the team, the government, if they have data rights, whether it's government purpose license rights or whatever, they're entitled to provide that to the prime contractor, regardless of who's on that prime contractor's team. So there's no limitation there. Competition, if the teaming is going to affect competition either, as I mentioned before, for the instant procurement or possibly future procurements, that could, like for component breakout during production, that could be a problem. And then lastly, holding the prime contractor fully responsible for the contract performance. The prime cannot obviously shirk or blame a subcontractor. They are going to be responsible. This next slide, I want to just go through quickly some key issues to address in teaming agreements. Some of these are pretty obvious, I think. The first being, what is the program or the opportunity that's being covered, and how much does it cover? Does it exclude or include follow-on work? There may be several phases to a program, and you may only want a team on the first phase or the first couple of phases, and then be allowed to do the work in-house or team with someone else later on. So you want to be specific on how much of an opportunity, how many phases of a program are being covered by your teaming agreement so that you avoid misunderstandings later on. Work split. How precisely is it defined? Is it guaranteed, or do you have a right of first refusal? This is very important, and I can't tell you the number of times I've reviewed a teaming agreement where this was something that was not even hardly addressed at the outset. And it's just I think, pretty basic that the parties understand if they're teaming who is going to be doing what should they win the program. If it's too vague or it's not guaranteed, subcontractor may decide it's not worth teaming. And the other aspect of a vague work split is that in some jurisdictions, a teaming agreement may not even be enforceable. In Virginia, there are cases in which the courts have said a teaming agreement that has a vague split of the work is only an agreement to agree and is not enforceable.
So one question on that point. Assuming you're able to insert a fairly robust provision into the teaming agreement, for example, allowing you 20% of the work on a certain type of contract, how would you flow that into the contract terms itself?
Most of the time, if you're talking about a complex program, you're going to take parts of the RFP that are identified in the Section C of the RFP and identify specific parts of the work that you want the teammate to perform. If you can't do that, then there's formulas that you can use to say whether it's over the course of a period of time, 20%, or if you might get stuck saying 20% of each task order, which is not a very favorable thing. You lose a lot of flexibility in that regard. So there's different ways to do that.
It's important to make sure that the people who are negotiating the teaming agreement make those who are negotiating the subcontract aware of that kind of provision.
Correct. Team members' proposal preparation responsibilities and coordination duties. These, again, need to be clear who is doing what so that there's, when you get down to the proposal due date, you're not scrambling to say, hey, you were supposed to do this and you didn't do that. The duration of the agreement. This has to be a reasonable time limit under the antitrust laws. If you have a teaming agreement of something fairly lengthy, say more than 5 years, that may smell of an antitrust violation. So you need to be careful there. Exclusivity, I'm going to talk about that on the next slide. Again, that has some antitrust implications. Events that will terminate the agreement. Most teaming agreement templates, including the one that I've developed and used over the course of my time with Quest, CenturyLink, Raytheon, contain a pretty standard list of things which will cause the agreement to terminate. Depending on whether you're the prime contractor or the subcontractor, you may want to add or delete certain parts from your standard template. For example, you may want to make the teaming agreement, if you're the prime contractor, easy to get out of, especially when the teammate is not carrying their load. They're not providing competitive pricing, for example, or not writing a compelling narrative on their technical performance. On the other hand, if you anticipate multiple proposals under a teaming agreement, you can do that where the teaming agreement is only terminated with respect to any prime contract or task orders that are awarded, and the teaming agreement would continue on for the subsequent proposals. Proprietary information, again, very important that this be included because you're going to be exchanging proprietary information, especially if you're a subcontractor, you're going to be providing that to your prime, and you want that to be protected. Normally, I would recommend that you incorporate a signed non-disclosure agreement, but you can have separate provisions in the teaming agreement if you like. I mentioned exclusivity earlier, and the question is, should you seek exclusivity or try to avoid it? And I think it depends on your perspective. If you're the prime contractor, the prime contractor normally wants its potential subcontractor teammates to commit to exclusivity while preserving the option to team with others for same or similar work, or perhaps perform the work in-house. When you're a subcontractor, you have a different perspective, and that's that you want that prime that you're teaming with to team exclusively with you for preferably the life of the program, but perhaps have the ability to, or the option to team with others. Some problems with exclusivity. I think there are several. And typically what happens in my experience is that you end up either both being exclusive or both being not exclusive. But if you're going to be exclusive, from the prime contractor's perspective, you need to be concerned that you're not tied to someone that's going to cause you to lose the bid. Subcontractor may not have much of an incentive to provide long-term cost and schedule control, and this is one thing where you can use early termination language to keep the subcontractor in line, that they get their work done correctly. Federal agencies sometimes will closely scrutinize these. The Department of Defense has memos out that says, you know, and National Reconnaissance Office, among others, do closely scrutinize these, so you need to be careful there. The one thing I didn't list here is that as a prime contractor, you might have a problem with exclusivity that causes issues with regard to terms and conditions in your prime contract should you get the award. If you have to perform, say, you're a small business and you have to perform more than 51% of services, or you have a subcontract plan with goals that may be more difficult to reach when you're exclusive. So you need to perhaps think about carving those out from an exclusivity arrangement if that's the way you go. On the other hand, non-exclusivity provides other kinds of problems. There's a greater risk of compromise of proprietary information or use in support of a competing team. Also, your subcontractor may not provide the best personnel for your team. They may give you the B team, or they may have a better pricing arrangement with somebody else. So you want to be, concerned about how much support they're going to give you, the best prices, whether or not there's a possibility of technical transfusion of your strategy or your solution or whatever.
On exclusivity, if you're a subcontractor and say your prime is insisting upon exclusivity, but you're concerned about being tied to a loser, for example, on a task order, are there steps you can take in the teaming agreement to mitigate that?
You're talking about from a subcontractor perspective? I think it's harder unless you have a provision that basically is a notice provision that says, provided that you provide notice not more than a certain number of days prior to the proposal due date. That's the best thing to have. The prime is going to insist on some kind of a notice provision or some kind of a cutoff date so that you don't leave them in the lurch at the last minute. Do you have any other ideas there that?
Well, particularly on a task order basis, one thing I've done in the past is, okay, prime, we'll be exclusive to you, but if you lose this task order, we reserve the right to subcontract with the winning company. Okay. Somewhat successful with that approach.
Yeah, a lot of times you'll see a provision that says, and provided that all avenues of relief, such as protests, are exhausted, then that leaves you free to go make a proposal to the winner. Yes, ma'am.
I have a question about using prior performance data in a non-exclusive teaming arrangement. Is there any concern with, contracting officer looking at 4 different packages and seeing the same performance across those? Is that something that we worry about?
So the question in the room was if you had, for example, a subcontractor that was teaming with multiple prime contractors, all of whom are using the past performance data of that same prime contractor, and is there a concern with disclosing that or with protecting that information?
Yeah. I would say at the outset probably not. That's not a problem because as long as you've committed to using that particular subcontractor for your performance, at least in your proposal, even though you're non-exclusive in the sense that the subcontractor can provide proposal support to others, you're probably okay, and the contracting officer will consider it. They're not likely. Most of the time, the government doesn't ask for copies of your teaming agreements. So we're going to get into some issues to look at when you're actually reviewing a proposal. One of them would be a misrepresentation of fact. So if you have really no intention of using a particular subcontractor, that might be a problem. Yes, ma'am.
In light of that, when you talk about the duration of the teaming agreement, extinguishes or closes the teaming agreement is the execution of a subcontract. Only when you do subcontracts, especially in IDIQ situations, you don't put the guaranteed language in there. What recourse does a sub have when they get into contract performance and they're not getting what they were promised in their team?
So the question in the room was, particularly in an IDIQ situation, if you're a subcontractor, you're not a winning team. Typically, one of the terms of the teaming agreement is if you're awarded a subcontract, the teaming agreement goes away and it expires. So the question is, what guarantees do you have in that period between the teaming agreement expiring and when work is actually awarded to guarantee that you're getting the work share that you negotiated?
I think the simple answer to that is to have strong terms and conditions in the subcontract that is replacing the teaming agreement. And you may have different language in there regarding rights of first refusal or whatever, but if you don't negotiate something which guarantees you the right to the percentage of the work or the type of work that you had originally supported in the proposal preparation as part of the teaming agreement, then that's kind of a shame on you kind of a thing. However, I do obviously sympathize with being on the subcontractor side where the prime contractor will do sometimes their best to ignore what they had previously promised in the teaming agreement. So I think the best answer I can give you is make sure that your terms and conditions in your subcontract are strong. Just quickly, I want to address MOUs and letters of intent. These may be desirable in some situations. Sometimes people call them a pre-teaming agreement. The companies I've seen that typically want something like this would be a small company that is leery of dealing with a very large company, that they're afraid that they're going to get their technology stolen or not get the work. And so they want some kind of assurances that the large company is going to treat them fairly. So they ask for an MOU or a letter of intent. Normally, these are intended to be non-binding documents. And so sometimes you'll say, well, it's an MOU. Why does it need legal review? Well, the fact of the matter is some MOUs and letters of intent will contain commitment language or agreement language. And so my policy was they always needed a legal review and approval before signing. I would suggest also that a non-disclosure agreement can substitute for an MOU or a letter of intent in the sense that it provides that toe in the water good feeling that a subcontractor would have by saying, okay, we're talking about whether or not it makes sense for us to team, and that's good enough. And plus, at least with an NDA, you've got some protections on your proprietary information. Okay, I want to switch over now to communications with the government before the RFP is released. Basically, they're allowed, they're encouraged. You have a question?
Yes. Just a quick question. Is there a sample language or templates in the materials that are online for MOUs or teaming agreements?
There are not, but I can provide that to you if you specifically need it.
The question in the room was as to whether templates are included in the materials, particularly for MOUs or teaming agreements. You will find in the ACC library a decent stock of those as well, if you look online.
Okay, so on this slide we talk about communications before the RFP is released. There's reasons for both sides for wanting to have free communications before needs have been validated or fully developed and funded. There are some types of information that are not to be disclosed or discussed, and I've listed these on the slide as well. Those that would provide an unfair competitive advantage, proprietary information of competitors, source selection information, and of course classified information has to go through existing security channels. Even though communications are encouraged prior to the RFP being released, you'll find that some government folks just don't want to talk to you. So how do you get them to talk to you? How do you get them to talk to you? I think the only thing that I could recommend is that you try to emphasize the benefits to both sides for why communications are important, so that they understand what you can provide and you understand their needs. After the RFP is released, we have a different story here. The government's required to furnish identical information to all prospective offerers as simultaneously as possible through authorized channels like Fed Biz Ops. And it's basically so that no one gets an unfair competitive advantage. The RFP normally will provide a formal process for asking questions and a cutoff date that's usually pretty short. You got to find that in Section L of your RFP. Other communications are sometimes the RFP will say they're prohibited or they're strongly discouraged, and this is to avoid appearances of favoritism. The question is, well, what can you do, or what kind of communications? If you can't go through the RFP, what might you think about doing? And I would recommend that. Well, you don't want to necessarily have a program-to-program folks talking, but maybe the best course, if there's a significant issue that needs to be brought to the government's attention, have it go through your legal department, okay? You guys talk to the lawyers on the other side. Can you ask questions after the cutoff date and time in the RFP? And my response is, yeah, of course you can. They're not going to necessarily answer them, but if it's a critical point or it would otherwise benefit the government to answer the question, they will. Best practice, shred the RFP, find out what the requirements are, and this will reveal where questions are useful. Normally the government answers questions in writing. They'll state what the question is verbatim, and then they'll provide the answer, which may or may not be very helpful. Often it's please refer to the section blah of the RFP. Why do they do that? That's basically because they're afraid that they're going to somehow mess up the procurement. When you're formulating your questions, and this is where I think General Counsels can play a significant role. First of all, you want to be careful how you draft your questions so you don't reveal competition-sensitive information, such as your identity that you're even bidding, what your bidding strategy is or what your technical approach is. So think about it. If the government won't give you a straight answer and you're worried about risks of disclosing your competitive, why bother asking questions? That's what some people say. What's the point? Well, questions are often used to try to get the government to change their requirements. Maybe they can't be met, or they're too costly, or there's a better way to meet their requirements, a better way for you to meet the requirements. So that's, I think, a good reason. A better reason, though, is that you may find ambiguous requirements and they need to be clarified. Remember the rules of contract interpretation regarding patent ambiguities, that if you fail to ask about a requirement that's subject to more than one reasonable interpretation, then you may be stuck with the government's interpretation.
And on the opposite side, if you think the RFP is clear, definitely read the answers from the government, because sometimes the government will muddy the waters in the answer. That's
a good point. Artful drafting, I think, will help you validate what your interpretation is and maybe get the government to, if they fail to clarify, it provides you with ammunition later that your interpretation is valid. Question, can you rely on government answers that do not get incorporated in the RFP? And you'll see a provision a lot of times in Section L that will say, no, you can't rely on, unless we amend the RFP, you can't rely on our answers. I think that makes sense with regard to changes, but when you're just talking about clarifications, I think there's a legitimate room to argue that you can rely on them, even if they don't amend the solicitation. I want to talk just quickly about responding to the substantive requirements. I think this is really the meat of what I think you can, once the RFP is released and the proposal's being prepared, I think you can play a very active role in the proposal review and the submission process, and it's very much appreciated when you do. So try to get on red teams or gold teams or even green teams, which basically refer to pricing. My preference was to get on the gold teams so that right before the proposal, the actual proposal that we were planning on submitting, I could address the following issues. First of all, misrepresentation of facts. If we state something that is just a flat-out misrepresentation of what our product can do, that could lead to a protest, or it could be a false statement. And they can be remedied simply by changing the language from, our product has the following attributes to our product will provide the following attributes, something like that. Completeness. Many competitions are lost due to simple mistakes where we just fail to respond adequately to the requirements. So you need to compare the proposal requirements, the RFP requirements to what you're saying in your proposal. And if it doesn't meet the mail, ask the questions. Consistency. You'll see that sometimes, and especially a complex proposal, that you got different people writing different sections of your proposal. You may have a subcontractor that writes something that some part of the proposal, and you may be the first one to read, or the only person to read through the entire proposal. If your proposal is not consistent, the government evaluators are going to pick up on that and they're going to downgrade it. Clarity. This is pretty straightforward. A proposal that's easier to read is going to be score higher. So ask, what do you mean by this? Ask your proposal team, and don't be afraid to try to rewrite something to make it more clear. Regurgitation of the RFP requirements. That, yeah, we understand and we'll comply. That's a favorite answer of a lot of people, as opposed to explaining how they intend to comply or to meet or exceed the requirements of the RFP. Sometimes understand and will comply is okay because there isn't any more need for an explanation, but it's lazy if they are asking you for how you're going to comply and you're not going to score as high. Exceptions to the RFP requirements or the terms and conditions. need to check Section L. Can they be negotiated, or will they cause you to be disqualified? This is the easiest way for the government to kick you out of a competition. And finally, legal issues. There will be some legal issues. You need to make sure you're describing the legal entity that's bidding on the as the prime contractor. You may have to describe your team member relationships, required legal forms, and especially intellectual property disclosure and marketing requirements. Okay, I'm going to skip the last couple of slides in the interest of time. There's a compliance slide. Basically, the last bullet there dealing with training and appropriate policies is the key thing there. And then on the small dollar proposals, I've listed the things that even if you're not writing a detailed technical or management proposal, you still need to check these and make sure that they've got everything covered. And of course, we're not going to talk about Battle of the Forms. I know that's everybody's favorite topic, but that's a whole another hour in and of itself. I'm going to turn it over to Tom now to talk about OCI's personal conflicts of interest and past performance. Thank you.
By way of introduction, I've been in the government for half my career and in private practice the other half, and so I always used to counsel the government employees, if you don't have a good answer, don't say anything. Just say, look at the solicitation. So you can blame me for all of these answers that we get, and I'm so frustrated, but it does teach us to make a thoughtful question, prepare a thoughtful question that's not going to call into question, particularly a term that we like. We would like to see stay in the solicitation. We always look at proposals, and I always look at performance. How are we going to surveil performance? How are we going to administer the contract? And so that's really an important thing that we want to make sure that we focus on, because there's some real practical things that will pay off. I'm going to talk about something that's really easy, and it's something that gives us high marks in our evaluation with the government. But oftentimes, it's a subject that derails even the best articulated proposal to an RFP, and that's conflicts of interest. In my experience, General Counsel, Corporate Counsel know this area of the law very well. There's a lot of training, and there's a lot of discussion about it. In my experience, companies don't execute in this area nearly effectively enough. And so I'm going to talk about three things. Number one is the organizational conflict of interest. Number two will be personal conflicts of interest, which oftentimes gets a even further backseat, and the role of the warranted contracting officer. Very simple. The contracting officer is in charge in this area. The contracting officer has the responsibility to avoid, neutralize, or mitigate potential significant conflicts of interest. I've challenged conflicts before, saying they're potential but they're insignificant. Don't make that challenge. That doesn't work. Never works. If it could be a conflict, consider it a potential significant conflict of interest and deal with it. And understand that the contracting officer is supposed to avoid. And how does the contracting officer avoid? The contracting officer avoids by taking the mitigation, avoidance, and mitigation plans that we submit, and they use those and administer those to avoid the conflicts of interest. And we're really looking at three areas. The boards and the courts look at bias, they look at unequal access to information, and they look at impaired objectivity. If your company operates or your subcontractor operates in the areas that we've listed here as flags, know that there's probably some conflict of interest work to do. If you're doing management support, preparing technical proposals, cost evaluation, if you're defining requirements, preparing specs, if you're doing systems engineering, providing technical advice, making product recommendations, brand name or equal, you're doing systems integration, writing policy, or furnishing systems or supporting systems, it's likely that there's going to be an impact in the conflict of interest arena, either on the contract at hand or in future contracts. So just bear this in mind, particularly when you're choosing a teammate. OCI analysis is part of business planning, in my judgment. And when we advise clients, we try to get them to think about organizational conflicts of interest, personal conflicts of interest in their normal business planning, in their strategic planning, because we don't want to pursue a program or a course of action that we know will create a conflict. And I was in a discussion yesterday with a client where they did a no-bid, made a no-bid decision, because if they were to bid, that would create a conflict with one of their divisions. And so it should be considered in the strategic planning, it should be considered with respect to future revenues, and it should be considered especially when we're talking about adding or divesting a business unit from the corporation. So the first time that you see an OCI issue or a PCI issue should not be with the RFP. It should be part of the normal dialogue within the company, within the corporation, so that when you get to the RFP, you know exactly how the OCIs must be mitigated in order to promote the corporate long-term strategic plan. Make sense? And we talk about it because I'm always amazed. And you have to understand, as a private practitioner, nobody comes to us very often and says, oh, by the way, we just really had a great outcome with a teaming agreement. We get the other side of the question. Oh, we should have had a teaming agreement, or we should have put the teaming agreement language into our subcontract. And so I think these are all things that really are part of our art, if you will. So what do we do if we have a conflict of interest? It's not a big deal. We see many companies try to hide the conflict in a teammate, in a subcontractor. We see many companies try not to disclose the name of a key personnel. The best practice is disclose, disclose, disclose. You disclose the conflict and you disclose your avoidance and mitigation plan. We call it, Chip will say, the identification, avoidance, and mitigation plan, because we want to have a plan that ongoing, as we go through our procurement cycle, we'll identify conflicts as they arise. Even with the best planning, we still find ourselves having to address conflicts of interest. And so I can't stress this enough. And just think in terms of disclosing to the one who has the authority to manage conflicts. That's the contracting officer, the warranted contracting officer. It doesn't work to give the information to a COR or to some program management official. It must go to the warranted contracting officer, but it also must go with the plan of action, the implementation of a pre-existing mitigation plan, and how you're going to deal with that OCI. And also, hand in glove with the organizational conflicts of interest, we have the personal conflicts of interest, and these can be very, very difficult to deal with. A subcontractor that we dealt with a couple of weeks ago got this subcontract because of the skill set and the experience of one single individual who was declared to be disqualified for personal conflict of interest. Subcontract laws, because this was a skill set that was not easily replaceable. And so if you're a company and you have the cited clause from this slide in your contract, it's your duty to prevent personal conflicts of interest. And that means that you need to have employees that are coming into contact with non-public information. And if they're employees that have non-public information and they're doing something that's inherently governmental in function, that's a covered employee that must be dealt with. And the way you deal with it initially is with a non-disclosure agreement where that employee will agree not to disclose any non-public information in any way other than to perform the official duties that they have right before them. And so we must ensure that we protect the non-public information. Joe will talk a little bit later about public information, but here when we're talking conflicts, we want to make sure we're focusing on are we doing an inherently governmental function, and are we also in possession of non-public information. The slide that I just clicked on gives us the requirements from the two FAR clauses that deal with PCIs. And it's very simple. As counsel, we go through this checklist and we make sure that we have people in the corporation that cover each one of these areas. I want to, and you can refer to that, and I think that's a very good checklist. The one I'll highlight is oversight, number 4. Maintain effective oversight. It's not enough to do an NDA. It's enough if you perform diligence and you make sure you update the non-disclosure agreement. you make sure you update your policies. You make sure that there's no conflict when you do interviews, desk site interviews with covered employees. And I wanted to bring to your attention some just key considerations that I look at. First of all, is the function that we're doing likely to be contracted out? Is it part of a commercial, industrial type activity, as we used to call it, that could be contracted out, given to the private sector? Is it inherently governmental in its task? And so, if you don't know if it's borderline, this is a good area to have a dialogue with the government official, the contracting officer, maybe to get a determination or your determination confirmed. When in doubt, treat it as when in doubt, you treat the function as inherently governmental if you have a question. And the PCI only applies to covered employees. These are employees doing inherently governmental tasks, and they're dealing with non-public information. If the whole rest of your workforce doesn't work in this area, they're not covered by these PCI rules, and the corporation's not covered by these PCI rules. Again, the key is non-public. And really what we're focused on here, this is the conflict. When somebody uses the knowledge they have from having a government position where they have non-public information, where they've done inherently governmental functions, and they can use it to impair in such a way that their objectivity will be impaired, or they can use it to get a job. They can use it to advance a financial interest. They can use it to promote any personal family tie type of issue. If you've got this situation, it must be dealt with. And we deal with it simply with NDAs, with employment agreement, with contracts, and with diligence, good solid diligence. We advise always to take a compliance agreement that you have with an obligation with an employee, put it in their employment contract. Put the NDA in their employment contract. It gives you another tool to deal with conflicts of interest. Best practices. The practice that we see is private outside counsel is the key employee that's not identified, buried within a subcontractor, and then when you start doing the diligence on this key employee, you find out that that employee has the name who happened to be the former program manager of the program that you're bidding on. That would be a problem that would need to be mitigated. And so the first thing is identify key personnel by name. We want to insist and assist to the highest standards, and we want to make sure that we exercise some leadership. Appoint an individual to oversee this, use employment letters, as I mentioned, and charge employees to investigate if they see it, just generally, but to report the conflicts using the hotline or making a personal report as well. This should apply to subcontractors and teammates as well. I'm not going to talk about past performance with affiliates and subcontractors. I put some slides in the deck here. I just want to note one thing. If we're going to use the past performance of an affiliate or subcontract, we have to put sufficient facts in our proposal so that the government knows who's going to perform the work, who's responsible for performing the work, who's going to provide the resources so that all of the key terms are covered. It must be facts. It can't be a general glossy statement that the team is going to work. You need to specify by individual, by subcontractor, by teammate, who is specifically going to do the work and who is specifically going to resource the work. And I put a couple of cases in here to take a look at where we're given the pronouncement by courts and boards that if we don't have facts, likely our solicitation response will not be acceptable, and a protest could be sustained, or they'll move on to another awardee. Let's talk about protests.
Thanks. I'm Chip Purcell. I'm going to talk to a few minutes about pre-award protest considerations. I think a lot of this is area that you're probably all familiar with, so I'm not going to spend a lot of time on it. But just as part of the process that we're talking about, reviewing an RFP, some sort of a solicitation, putting a proposal together, thinking about the pre-award, how a pre-award protest figures into that, to the extent that it does. I think my view, and I think my colleagues would share it, is a pre-award protest is really a last resort in this process. you've gone through the regular process, and Ray talked about particularly the Q&A process with an agency where you're getting the agency to address some sort of an issue that you've identified with a procurement. If the agency is not responsive, if the issue has not been resolved, a pre-award protest is a viable option to get, whether it's at the agency level or somewhere else like the GAO or the Court of Federal Claims, get that issue to be recognized and considered. So what are some pre-award protest considerations? I think a lot of these are things that Ray talked about. Is there an element of the solicitation that somehow precludes you as a company from competing fairly, in your estimation? Does it favor another competitor? Or is there some sort of inherent ambiguity in the RFP that's going to lead to a competition that's not going to be on equal footing? Get the agency to address that. And through that process, again, the first avenue should always be the Q&A process, rather than going to a protest. The normal Q&A process that the agency has, or outside that Q&A process, trying to dialogue with the agency to get them to recognize whatever that issue is. Ambiguity, some sort of favoritism, some element of the RFP that you think should be there that's lacking. Reach out to the agency to get them to address the issue. Among the other considerations, the one that I'll hit on briefly is we often, in working with our clients, coming up to a proposal submission, we've got some sort of an issue that's not been addressed. We're considering filing a pre-award protest. A question often arises, well, what should we do? Should we go ahead with our proposal submission? Our view is always yes. Get your proposal in, even if there's an outstanding issue that has not yet been addressed. Don't prejudice your ability to compete for that procurement by not submitting a proposal. I mean, often these things can run concurrently. But you're better off being part of the procurement process by submitting that proposal and competing. Pre-award protest grounds. I'll walk through these very briefly. I think a lot of these are things you probably run up against before. But unduly restrictive terms. Is there some element of the RFP, whether it's in the specifications of the statement of work, that doesn't say necessarily state the agency's minimum requirements? The agency's put in there something that's it's not going to allow that. It doesn't necessarily reflect what it is that they're procuring. Does the solicitation contain ambiguous or inconsistent requirements? Is there some element of the RFP that's open to two or more interpretations? Something that makes the requirements vague. Again, raise that. The Q&A process is a perfect way to do that. But again, if that vagueness remains, a protest is an avenue to make sure the record has been made. This ambiguity exists. The agency hasn't addressed it. Failure to include a mandatory clause, or likewise when the agency is included in the solicitation some sort of clause that should not be there. A solicitation requirement that favors another offerer. Has the agency drafted the specifications in a way that would allow some competitor, whether through a product or a service, to fulfill that, while you have some product or service that meets the underlying requirements, but the specifications are drafted in a way that it unnecessarily favors someone else? Improper bundling of requirements. Is the agency combining some sort of requirements in a way that's going to preclude you from competing? Are they doing it for a legitimate reason, or is it not laziness, but something that doesn't necessarily serve the agency's bottom line? Does the solicitation employ an improper evaluation method? The key, again, is that the agency has to be able to evaluate offeror's competitor evenly. Does that, the terms, particularly in Section M, allow them to be able to do that? Is there going to be an apples-to-apples comparison among offerors? Has the agency improperly disclosed proprietary information? Has the solicitation accurately reflected some sort of change in requirements that the agency now has? Where the agency has moved away from full and open competition, is there a legitimate reason for that? Is the agency, can they, whether it's urgent and compelling circumstances, some other of the recognized means for moving away from full and open competition, is there a legitimate reason on the part of the agency to go that avenue? One of the other things too we like to do with our clients is think about, and Ray again talked about this as part of your proposal preparation protest, make your proposal as protest-proof as you can. And I think Ray talked in detail about the steps that are involved in making sure that when you submit a proposal, it matches up with the requirements of the solicitation. Is what you're proposing accurate? Are you meeting, have you provided all the elements that the agency is looking for? We've seen a lot of protests lost where an offeror has not spoken to a specific requirement, or they've done it in a way where it doesn't match up with the instructions that the agency's laid out within the solicitation. So a little time, but some amount of time going into the proposal submission, thinking about, is it a fulsome proposal? Does it speak to all the elements that we need to be speaking to? Is that done? And I think with this, we've got a slide here shining a light on sections L and M of the solicitation as part of that the proposal review process, particularly with respect to section L, making sure that for each of the elements of section L, your proposal matches up with those, and you've answered those requirements. So that, in a very condensed version, is our discussion of pre-award protest issues.
Thanks a lot. I'm Joe Berger, and I'm going to talk just for a couple of minutes on public information and corporate transactions in the context of both proposals and bid protests. So I'm going to zip through these slides, and we'll get into the facts. But there are some facts from a couple of case studies in the slides in case you want to take a look at them for reference. But I'm just going to talk about some high-level points to keep in mind both during proposal preparation and for potential bid protests. Starting with public information, it can and will be used in a bid protest either by you or your competitor, and a GAO is more likely than the Court of Federal Claims to consider information outside the record, but GAO commonly does so. Public information can be relevant beyond the context of corporate transactions. For example, it can be relevant to proposed solutions. For example, your website might talk about your technical solution as being XYZ, but the solicitation calls for ABC, and your competitor might challenge you based on that. It can also be relevant to corporate experience or past performance. So this can be used by a competitor to challenge your proposal and your evaluation. It's more complicated in the case of a pending corporate transaction because they're also governed by the securities laws. And common sources of public information are a company's own website, your press releases, SEC filings, and the news media. So briefly, just a couple of case studies, and we include Wiley here as context for the next case, Lockheed Martin, which is more recent. And very briefly, the basic facts that you may know, one great company, which was SAIC, had a corporate split and became two great companies, SAIC and Leidos. And I say that not just because they're here today, they're speaking on the next panel. They are great and fantastic companies with a very interesting history in government contracts. Now, the result here was that a protest was sustained based on this corporate split. GAO found the agency did not properly evaluate, and also the proposal did not properly address the transaction. And this is GAO's digest. And this is the conclusion. And NASA requested reconsideration because this was a precedent-setting decision. Reconsideration was denied, and GAO affirmed its previous decision and gave a little more guidance. Basically, the guidance is that proposals must be consistent with the stated restructuring plan. And that brings us to the next case. Pretty recent, Lockheed Martin Integrated Systems the facts are different. Here, the agency excluded Lockheed's proposal due to a pending corporate transaction, which also by chance happens to involve Leidos. We may hear a little more about this on the next panel. But Lockheed Martin protested. Its protest was denied. GAO denied Lockheed's protest because the agency's evaluation was reasonable and reasonably considered the upcoming transaction. GAO made this decision in the context of Wiley and other similar decisions. For example, VSE, in that case, GAO found that the plan was indefinite and didn't trigger any obligation. In contrast to Wiley, in Wiley, the transaction was imminent and essentially certain. Those are the key words. And GAO now is giving the guidance that an agency should analyze the effect of a possible corporate restructuring when the transaction at issue is imminent and essentially certain, quoting back to the NASA case. And so the outcome for Lockheed was that GAO found the agency could reasonably conclude that the transaction was imminent and essentially certain, and the agency could consider a press release and evaluate the possible impact on the proposal. So lessons learned. I know we only have a few minutes left. The agency can learn of a transaction through the media, a press release or other means. It can consider the information. It can exclude a proposal. It can take this action based on public information contained in a press release, and it might not consider additional information that might be out there in SEC filings. And according to GAO, an agency should analyze the effect of a possible corporate restructuring when it's imminent and essentially certain. So under those circumstances, a company should address the plans to the extent it reasonably can in the proposals. And detailed plans disclosed to the SEC indicate that the transaction is imminent and essentially certain. Again, reconsideration requested and denied. And GAO again went over the facts and gave more guidance, addressed the manner in which the agency considered the transaction. GAO endorses its prior decision, which defended the agency, again, based on the transaction being imminent and essentially certain, and defended its decision as consistent with prior case law, but noted that the case law is fact-specific. And GAO notes an agency is permitted to consider information outside the four corners of a proposal. And so, GAO again advises agencies to consider restructuring when it's imminent and essentially certain. And here the transaction was not uncertain, and it was reasonable for the agency to consider it. So lesson learned, it's better to address the information in your proposal to the extent possible and legally permissible. And so briefly now, just a couple of slides on lessons learned. If your competitor has announced public plans for a transaction that are imminent and essentially certain, and that could affect performance, that may be grounds for a protest. But more importantly for you, if you have announced public plans for a corporate transaction and they're imminent and essentially certain and it could affect performance, that may provide grounds for a protest to your competitor or to the agency to exclude your proposal. And so it's the best practice to reasonably address the available information in your proposal so that the agency can reasonably consider it during its evaluation. And just one last slide to wrap it up on public information. Public information can be used in a bid protest, and it can be used to challenge your proposal and your evaluation, and not just in this context, but in the context of past performance, corporate experience, proposed solutions, and corporate restructuring. And so if there's public information that bears upon your proposal and that might be considered by the government or used by your competitor in a bid protest, it's the best practice to address the relevant information on your own terms in your proposal. Here's our contact info, and thanks for listening. And are there any questions for anyone on the panel?
Well, at this point, we must conclude the session. On behalf of our chapter, I'd like to extend a special thanks to our sponsor, Thomson. and to our panelists, Joe Berger, Chip Purcell, Ray Mccann, and Tom Mason. We'll now take a 15-minute break before our next session. We'll be placing the webcast on hold, and we'll return in 15 minutes. speak right now. Welcome back. It's now.
I'm sorry.
Welcome back. It's now time to begin our second panel titled Protest Strategies, the GovCon Guide to What, When, Where, and Why to Protest. Brought to you by ACC National Capital Region and Proprietary Law PLC. Once again, all remarks made by these panelists are their own opinions and do not constitute legal advice or necessarily reflect the viewpoints of their company or firm or of ACC National Capital Region. It's now my pleasure to turn it over to Debbie Hewitt to introduce herself and our other panelists.
Thank you. It's really great to be here. I was saying to Courtney on the way over that there's nothing more that an attorney likes but a captive audience. So, I'm really excited. And I also asked Matt that I introduce myself because obviously I know more about myself than he does. One thing about bid protests is that they're ubiquitous now in government contracts in that industry, and if you Google bid protests, you're going to come up with hundreds of presentations about bid protests from lawyers. So why do I have the audacity to come up here and speak about bid protests? And I will just say that I've done a lot of them. I say in my bio that I've done over 100 protests, and while that sounds like hyperbole, I'll just say that when I first started at a firm, in 1990. I did 8 protests that year. I did 12 protests last year, and we're, I guess, in June, and I think I've already done 4 or 5 this year. So I really have done a number of protests, and I've done them for large businesses, small businesses, so I've also done them, in terms of SBA, set-asides, and the like. Some of, large businesses I've done protests for are Mantech, and Jeff Brown was here, the General Counsel. He and I go way back. I've done them for SRA, and Ann Donahue was here. I've obviously done them for SAIC and Leidos, and obviously a lot of small businesses. I also have experience on the other side. For 3 years, I was not in a law firm, and I served as a consultant to Cigna in Nashville on a huge protest they did, and I participated in the red team, blue team, and gold team reviews of their proposals. So I have that as well. And of course, I do transactional work, and I have a specialty on small business compliance and programs. I will now have the pleasure of introducing Courtney Edmund, who is at Leidos. Courtney and I have worked together, so if you want to hear all the bad stuff, you can talk to him later. Courtney has a very varied career as well. He started in the Air Force, was stationed in various countries. He actually became a contract specialist for the Navy and then moved to MITRE Tech, which now is Noblesse. And then he's been an associate at some very well-known government contract firms, Sidley, McKenna, and Fried Frank. And I'm not saying you should hire those firms, but they are very well-known in the government contracts arena. And then he is now at Leidos. And how long have you been there, Courtney?
9 years.
9 years.
Yes.
So he, too, is a veteran of this protest process and procedures. Now, the way I have approached this is to do something different when we talk about bid protests. Again, I did review a number of the presentations that have been done by other law firms, and they throw a lot of information at you, and there is a lot of substantive legal information. But for this audience, what I try to do is think about it from the in-house perspective. What are the questions you're going to get that are probably going to be lodged at you right away, and that your customer is going to, or your client, the in-house business division, is going to want to know right away? So what I've sort of done is a checklist. Here are the questions you're likely going to have to field, and these are the things that are behind the question that you need to know. And then Courtney, I think, is going to talk a little bit more about his experience and how that actually plays out during the process. I also want to mention that the slide presentation that I have up now is a little bit different than the one that was passed around to those who are participating in the webinar. Matt pointed out that my mathematical skills were lacking on a particular slide, which does not surprise anybody who knows me, because if I could do math, I'd probably be a doctor instead of a lawyer. And there's some other things. I also circulated a presentation or a paper that has the slides and the points on the slides, but also some more details that relate to the general points. Typically, I don't like to put everything on the slide. It's a little hard to see it. But I know that it's difficult to always write down everything you're hearing. So this sort of gives you some of the facts that relate to the major points. I know that people who are participating in the webinar don't yet have that, but we can easily provide it to you. So let's start. What is a protest? I think we don't need to spend much time on this. It's simply a challenge to agency action. And that challenge could come before a contract award, as the prior panel discussed, or after a contract award. Now, what are the questions that an in-house counsel is likely to get once a protest is going to be considered? And we've pretty much listed about 5 questions. Can a protest be filed? How much will the protest cost? What is the likelihood of success? What are the remedies that we're likely to get? And is there anything else? And on these slides, we sort of talk about or highlight the issues that you need to know in responding to those questions. And I'm going to turn to Courtney now, and if you could explain a little bit how these questions arise. What is the first question? What is the most important question from your point of view?
So one of the things you had to put in a little bit of context is when you get to this conversation, as the gentleman from Thompson Hine discussed earlier, there are different ways you can be involved in the procurement. Early on, often if you've been brought in at the what I'll call the capture phase, when the company is identifying various teammates, identifying various requirements in the RFP, you play a personal role and personal awareness of the actual procurement. And in those situations, you have background on a procurement, and you've in some ways advised the capture team along the way what issues might come up in a protest. And the other situation comes up where you get a phone call from whether it's the contracts manager or someone on the capture team, and they let you know that they've just been notified that we didn't receive an award, and we're either getting ready to go to the debriefing or came back from the debriefing. So in these types of situations, some questions in the latter situation is more of a rush because you're trying to get your arms quickly around the facts to make a determination as to whether or not you're going to move forward with what I'll call the protest process, and that process being understanding whether or not there are valid protest grounds, understanding whether or not you're going to take it up an internal approval chain. So generally the first question is, can we protest? And as you see here on some of the things here identified on the slide, there's kind of an intake process, trying to get your arms around what facts we have from the debriefing, and then also try to figure out whether or not we had some weaknesses in our own proposal that may have an effect on the outcome of the protest. And in terms of what is the most important question at that phase, I think the most important question, at least initially, is do we have a valid basis to protest? Because as you all can understand, some companies have higher thresholds for whether or not they're going to go file a protest. Some companies want to there's a lot of other considerations that have to be taken into consideration. And so, again, a lot of times it's, whether or not we have the valid grounds for a protest, and that really starts the process of whether or not the company is going to move forward with actually filing something.
Courtney, you mentioned the debriefing process, and frequently that's done in writing nowadays, but sometimes the government will offer an in-person debriefing. Do you find you attend those, or do you prefer to attend those? Do you send a representative from the in-house counsel's office?
My preference is generally not to have the attorney attend the debriefing because the debrief, generally savvy contracting officers, they'll try to stick pretty closely to the requirements in the FAR with regard to the information that has to be shared to an unsuccessful offeror. However, in some situations, if you have contracts managers or experienced business development members of the team in the debriefing, you can establish rapport with the contracting officer and maybe some of the other people there on the source selection team and actually get information that goes beyond the required information in the FAR. But if you have an attorney in the room, there's always that risk that you're going to chill conversation and that the contracting officer and other people on the source selection team are going to be very tight with the type of information they're going to share, and your chances for getting some information beyond what's required in the FAR are minimized, if not nullified.
I will add that often when clients call me and say, you know, there might be a protest, we're about to get a debriefing, I often insist in drafting questions and giving them, you know, an idea of things that they may ask that may be important for a protest that they may not consider. So that's some ways I think that attorneys can participate in that process without being visible at the outset.
Yeah, and that's very important too, because again, in any kind of organization, your contracts management team and your operational managers are going to have differing levels of experience with regard to bid protest situations. And so you may be on a situation where the lead contracts manager, for example, is very experienced with debriefings and trying to craft questions to get additional information. In some situations, they may not be that experienced, and I think that's where the lawyer is very valuable in that situation to help to guide them and to show them what types of information we want to get in order to be able to make a decision as to whether to protest or not.
So let's look at the first question. Can a protest be filed? What I think you should consider in terms of answering that question is figure out what the nature of the company's concerns are. What are they upset about? What have they learned from the debriefing that makes them feel that a protest is warranted? Timeliness is key. Just let me say rapid. And that should be your second question. You know, where are we in the process? Have you requested a debriefing? Have you had the debriefing? Have you asked questions? This DOD and civilian. We'll talk why that's important. But timeliness is very important. It will knock you out of the box immediately if you're not timely. The other issues are, you know, is the entity, the company, the right person to file the protest? Not all companies can file a protest. You know, for example, if you're a subcontractor, you can't file a protest. So that's some issues. We'll talk about that. And, you know, if you're going to file a protest, is the nature of your allegation something that a certain forum can review? So in terms of the nature of the company concerns, when you file a protest, you file a protest challenging pretty much one of two things. And one is, did the agency violate procurement law or regulation? And the second is, how did the agency conduct the procurement? And the standard of review there is for the GAO is whether or not what the agency did was reasonable in the circumstances and in light of the RFP or the applicable law. If you go to the Court of Federal Claims, it's a similar standard. It's whether or not the agency acted in an arbitrary or capricious way, or whether the agency used their discretion. I put bad faith up here because I'll give you a secret. Among certain lawyers, including myself, when I get a call and I talk to an associate and I said, oh, we've got a protest come in and, you know, this is the nature of it, sometimes I'll say, and, you know, it's a conspiracy theorist case. And what I mean about that is that there are a number of companies who are convinced there's a conspiracy against them, that the agency really doesn't want them, that the RFP was wired for a particular company, that there's somebody on the source selection panel who doesn't like them and is out to get them. I think what's really important to remember is that there's an almost impossibly high standard to make that kind of allegation. And the standard is, if I can even pronounce the words correctly, well-nigh irrefragable proof. And frankly, I think I've only been aware of one case where that was, where that actually carried a protest. But, you know, that's just not going to be a good protest ground. And it's a very sensitive issue because Generally, that's where the emotion comes from. So it's something to be aware that if you get, a sense of this unfairness, of this, intent of the agency to make your life difficult, that's something that you're going to have to manage because it's frankly a loser protest ground. Timeliness, you can break it down into two types of protest, pre-award, post-award. Pre-award, you just have to get your protest in before the due date for submission of proposals. The real timelines come after a contract has been awarded. And in that regard, you need to remember two things. There is a timeliness window for timeliness, when you need to file a protest based on your knowledge of the facts. There's also a timeliness window for getting something called a SICA stay. And a SICA stay is a process or a procedure by which you file within a certain time and the agency has to stop. It cannot proceed with the contract award. It either suspends or issues a stop work order or could even terminate the contract. And the reason that is important because you want to maintain the status quo. If it turns out that they proceed with the contract award and subsequently have to terminate a contract, the government's exposed to a lot of costs. Now, if there is an order or a court order that they cannot perform the contract or go ahead with it, they'll have to eat those costs. But as I talk later, the GAO, which is where the form in which most protests are filed, the GAO only issues recommendations. It's not a binding order. So agencies, in theory, can refuse to comply with the recommendation, and they may do so where the costs are so large if they've gone ahead with the contract. So a SICA stay is pretty much one of the most important things in terms of thinking about timeliness. And I have the times here. Briefly, it goes down to 10, 3, and 5, or 3, 5, and 10. You have to file a request for a debriefing within 3 calendar days, where a debriefing is required. To be timely in terms of the protest count, you have to file within 10 days of when you knew or should have known the basis of the protest, and that typically will be 10 days from a debriefing. However, if you have a required debriefing and you're looking for a SICA stay, you have to file within 5 calendar days of the debriefing or within 10 calendar days of the award, whichever is later. And it used to be, back in my day, that the government would conduct debriefings several days or, sometimes weeks or 10 days after the actual award, so that 5-day period was critical. Nowadays, I'm seeing more and more debriefings being attached to notice of award, and they're written debriefings. So you have to really consider the 5 and 10. Yes?
In what forum do you take the request for SICA stay?
That's a good point. Thank you. The SICA stay is automatic when you file with the Government Accountability Office at GAO, provided you file within the requisite time frames. The agency, if you file an agency protest, they are supposed to, it's not automatic, but the regulations state that they're supposed to stop the award. With regard to the Court of Federal Claims, there is not an automatic SICA stay, and the term SICA stay is not really applicable. But what you do when you go into the Court of Federal Claims is you seek an injunction. And there are 2 types. You seek a preliminary injunction, or a TRO, a temporary restraining order, to prevent the agency from going ahead. And then you litigate the protest, and then you ask for a permanent injunction to make sure the agency does not award following the protest. But the preliminary injunction is discretionary, and there are many factors that you need to prove before the judge that convinces him or her that the injunction is appropriate. Sometimes you get lucky and the agency agrees, but it's not the automatic SICA stay that most protesters are familiar with at the GAO. Oops. Whether or not you're an interested party, you have to show that your direct economic interest is going to be affected by the contract award and your ability to protest. So that typically means you're a disappointed offeror. Subcontractors, however, are not interested parties. And you also have to demonstrate prejudice. And this is something that might be hard for your in-house company client to understand. You have to show that you would have, likely received the contract award but for the improper agency action. Now that comes in sort of variations. You have to show a substantial chance you would have gotten an award. There are different iterations of that concept. But if there's a doubt, it's generally resolved in favor of the protester. Now, is there a forum in which that will hear the protest? And typically, you'll hear about three different types of forums. There'll be the agency, there'll be GAO, and there'll be the Court of Federal Claims. By far, the majority of protests are filed at the Government Accountability Office, primarily because there is this automatic stay, and primarily because it is a good medium on the cost spectrum. Very expensive to go to the Court of Federal Claims. It's not at all expensive to go to the agency, but you need to balance the likelihood of success about making those choices. So, for that reason, GAO is the primary forum. Other than if you are a disappointed offeror in an FAA procurement. They have their own forum. They're not bound by the FAR. Also, if you're going to do a small business type of protest, either size or status or NACE codes applied to procurement, you may lodge it with the contracting officer, but ultimately it will be decided by SPA. Now, beyond choosing a forum or the appropriate forum, you have to look at some other issues. You can only protest an award by a federal agency. And there are a number of organizations that you would think are a federal agency but aren't. U.S. Postal Service, non-appropriated fund activities, the U.S. Mint. So some of those agencies, there is not a forum that will consider those. The other big issue in terms of subject matter jurisdiction are task order awards. Typically, it's DoD. The value of the task order has to be above $25 million. For a civilian, it has to be above $10 million. That does not apply to task order awards off the GSA schedule. And the Court of Federal Claims does not have any jurisdiction to hear task order award protests unless the task order enlarges the scope of the overarching contract.
Devin, we had a question about filing with SBA and affiliation rules,
Yes.
especially with small businesses that have close relationships with large business.
Okay, you could do a whole presentation on that, but I'll cut to the chase.
Yeah.
If there's a small business set-aside procurement, an award is made to the small business. If it's just small business, the issue is that business small, quote unquote, under the size standard that's applicable to the procurement, and that relates to something called a NACE code. And typically the size standards are either stated in number of employees or revenues. The concept of affiliation comes into play where the small business that is awarded the contract may be, quote unquote, affiliated with some other entity that really would make it not small, or what they call other than small. Now, there are about 10 principles of affiliation, and some of them are intuitive and other ones aren't. Obviously, if the small business is, quote unquote, a subsidiary of a large business, the large business controls the small business. And really the concept is control. Is there a way that those two companies are either controlling one another or controlled by a third party? It is very fact-specific and complicated. But that is typically the basis of most, quote unquote, size protests. Okay, here's a favorite one that we're going to talk a little bit about, and that is, how much is it going to cost? And there are a lot of factors that go into that. Where you go to file the protest, and conventional wisdom is that it's not very expensive to go to the agency. It's really expensive to go to the Court of Federal Claims. But on the flip side, a lot of people think the Court of Federal Claims is going to perform a more exacting and careful review than the agency, because the agency is not going to, likely have the left hand, slap the right hand. So that's something to consider. This is where my math went awry. It has to do where, at least in my experience, the costs fall at the various stages of the protest process. And this is important because you can always withdraw a protest. And so there might be strategy that aligns with costs that would help you minimize costs and still get what you need. So in my perspective, a fourth of the costs involved in the protest has to do with collecting the information and filing the protest. Every time you document something, it costs money. That's where a lot of the money comes from. Writing something, even though it may be 10 pages, I remember at one point somebody used to tell me it's 5 hours per page. I mean, it seems unreasonable, but it's far harder to write something short than it is to write something long. So, whenever you write something, that's going to be a lot of cost. Reviewing the agency record, you would think, would take a lot of time, but if you're talking with a seasoned professional, I can get a huge record, but I can, pick out the 3 documents I need right away. I may have somebody else just look at everything else just in case, but really there are only 3 or 4 documents that are going to be critical for the argument of the protest. What is difficult is writing the comments. In some ways, it's double the cost of filing a protest, because not only do you have the allegations, but now you have the evidence to support the allegations. So that really is the majority of the cost. Now, you could review the record and draft the protest and review the record and have your counsel say to you, it's not going to really win. Or, yeah, I think we've got something here. And so at that point, you can make a critical decision of whether you want to pursue the protest or withdraw. And that's, in a way, you're cutting your costs dramatically by thinking about it in that way. And then there's always miscellaneous costs. You may have protective order issues, redacting documents. There'll be discussions with outside counsel, in-house counsel, and, all those sort of add up.
Devin, there's a question about the distribution of costs, and there's always a point at which decisions are made, probably in this stage. Do you find that your clients seek your advice on the cost-benefit analysis of when to proceed and when not to?
Absolutely. Particularly with the smaller clients who don't have in-house counsel. In some ways, I felt well situated to write this presentation, because I often am dealing directly with, quote unquote, the business people, the owner of the company, and there is no in-house counsel. So that's immediately, after the question of, do you have something, and can you file it, and are you timely? What is it going to cost? When I focus on those clients, I talk to them about how we can mitigate those costs, because for small businesses, it's a very costly event in their budgets. And as we say here, part of this slide and these 2 slides have to do with what increases costs and what reduces costs. And most of these are just factual matters. Certain events will increase costs, and that is whether or not the agency overrides the SECA stay. They have the ability to do that in certain circumstances. They override, and you decide to challenge that, you have to go to the Court of Federal Claims. That's really going to add to your costs. There's supplemental protests, so you're going to repeat those costs. You use expert or consultants. That's an additional cost. And whether or not the extent of the company participation, and I'm going to come back to that. In terms of decreasing costs, if there's an ADR process, that tends to be, that can end a protest in a much more economic way, whether the agency takes corrective action right away and the protest is resolved within the first 30 days, whether you can get reimbursement of your proposal costs or your bid and proposal costs, and then again, the extent of company participation also is important. So I'm going to focus here on two things, choice of outside counsel and extent of company participation, because that could be under the control of an in-house attorney. I'm going to first get to extent of company participation, and this is because it's a little pet peeve of mine, particularly when I'm dealing with small businesses. If I'm doing a protest and I ask the client to give me the relevant information, how they provide that information to me is going to affect cost significantly. I can tell you that often I get 30 documents, all the amendments, every iteration of the proposal, spreadsheets, notes. I don't need all that. I will tell you what I need. And more importantly, please conform the solicitation. Yes, I can read every amendment. I'd be happy to do that. No, I'm not happy to do that because really it's so boring, it's tedious, and it just ramps up the cost. Because remember, I'm not familiar with the procurement. So I need to, maybe Amendment 6, changed everything. But I don't know that, so I have to go back and forth. And time is ticking. So that's my concern, getting the raw information and the time allotted so you can make it a lot easier if you conform the RFP, you listen to exactly what I need and provide it promptly. Also another issue is, and this is a more difficult one, and I think Courtney can talk to this, is most of the time you're going to need to talk to the client. Obviously when I deal with small businesses, I'm talking to the owner of the company. But when you're dealing with a larger business, and Courtney and I have been in the situation, you talk to various constituencies within the company. You'll talk to the BD people, you'll talk to the people, the technical people, you'll talk to the business lead, you may talk to the General Counsel, you may talk to somebody else in the C-suite. And the usefulness of that information for me is not very much, but it's sometimes an important process for their comfort and their confidence in what you're doing. What it really gets down to, though, is ultimately you're going to have somebody in-house review the protest and tell you why the agency's conclusions are inaccurate. It's really helpful if you have in-house counsel to frame that in a way so the information is helpful to me. It is not helpful to be biased in reviewing the debriefing and say, well, that's just not right. Because I cannot tell you how many times I look at a proposal and say, yeah, it is. I'm sorry. I read this. I may not know enough, but didn't you say this? I mean, you need to have somebody who can really be critical because you want to make the allegations that are likely to be successful. You don't want to put out there something that you're not going to really win and, more importantly, diminishes your credibility. So, and then also some of the technical people don't understand how arguments are made, and so they'll provide you information that's really either too technical or not strategic enough, and you don't blame them, but I can tell you more often than not, I'll get the information and I'll say to myself, yeah, this is useless. I'll go ahead and do it. Now, I'm being very candid and brash, but this is all about the money, right? I mean, if you want a cost-effective approach to protesting, the more you do and the way you do it in-house is going to, for my opinion, drastically reduce the amount of time I have to learn about the procurement, analyze it, find the relevant information. Now, I'm going to talk to Courtney, maybe he has comments on that, or more importantly, talk about how you hire outside counsel, such as you did with me, and what are the sort of things you take into account.
Sure. So a couple of things that Devin mentioned in terms of, especially as it relates to extent of company participation. It's a time factor, not just a time factor associated with the various deadlines associated with the protest process, but also the time it's going to take for the company itself to get its arms around the facts relating to the protest or whether there are grounds for a protest, getting outside counsel involved and making sure that the outside counsel has the information necessary in order to put its best foot forward for the company. And so obviously there are a variety of ways to do that, and also it depends in many ways in terms of the experience of the contracts management team and the business development team with regard to kind of focusing in on the issues. Over all of this, it's what I call the 5 stages of bid protest grief. I'm sure you all have dealt with this before. You have the initial shock. What? We lost? And then there's denial. There's no way. We were the best company. We should have won. There is no way someone else got chosen over us. And then there's anger, and this goes back to the point that Devin had raised earlier in terms of this vast procurement conspiracy out there against your company. But then you get to the phase where you're into the analysis phase, where you're taking an objective view of the facts that you gain from the debriefing, and then also an objective review of what you provided in your proposal, so you can make that decision as to whether or not, aside from those other phases of bid protest grief, whether or not you have a valid basis to move forward with the protest. And so the in-house counsel plays an important role there, and it's three primary steps that I'll discuss, and that's kind of the intake process, the screening process, and then the outreach to outside counsel. So the intake process, that's done internally, where you receive that notification that you're an unsuccessful offeror. You're dealing with a lot of different emotions and things of that nature, because think about it, on some of the larger protests, larger awards, that capture team may have been working for 2 years to go after that particular award. They've gone through different types of reviews internally. They've sold it to senior management that we've got a really good shot at winning this particular contract. So people are coming in. You have some people that are focused on whether or not we have valid basis for protest. Perhaps some people are thinking, wow, I kind of promised that we were going to win this thing and we didn't. How is that going to affect me professionally? And then you have other people looking purely at the numbers in terms of this is going to affect our projections, revenue, things of that nature. So as the in-house counsel, you're taking all of that into consideration, but your job is to really focus in on, do we have valid bases to go forward with the protest? And in some ways, even if it's a personal situation where you're thinking, am I going to feel comfortable standing before the General Counsel saying that we should move forward with a protest, with the understanding that that focus is going to be on whether or not we have valid protest grounds, what are the potential outcomes and things of that nature. So I think in terms of the in-house counsel, your role is to get the team together. If, just say for example, if it's post-debriefing stage, to look at those facts that they say show that the agency did something improperly, and to take an objective review of those facts by looking at what was provided during the debriefing, trying to do at least the initial dive into the proposal documents and things of that nature to see if what the business team is telling you is consistent with what may be actual GAO protest grounds. And then at that time, I think, you're kind of at a crossroads where you're trying to explain to the people that, a lot of times emotions are still high, whether or not to move forward with a protest, or make that explanation in terms of why you think that a protest either would just be unsuccessful, or to at least discuss some of those alternative approaches that could receive some sort of equitable outcome for the team. That's a balancing act, because again, you delivering bad news, kind of with the understanding that your goal in that situation, if possible, is identify other ways that the company can still get revenue from that particular client. On the other hand, if you think you agree that there are some valid basis for protest, then kind of two tracks. One is whatever your company has established for an approval process. Of course, you'll want to start those notifications if it has to go all the way up to the CEO or some other executive. And then also identifying which outside counsel that you're going to use for that. Variety of factors obviously come into play: the size of the procurement, whether or not that award is strategic to the enterprise, experience with various outside counsel. A lot of companies have various types of programs where they've identified, say, a group of attorneys that they use for bid protests and other purposes. You'll want to decide, whether or not you want to go with a lower cost, high quality option, or whether you want to go with kind of the Lexus of bid protest attorneys. You're taking those things into consideration. And also the nature of the protest grounds. There's some attorneys that, at least there's a perception that with regard to OCI protests, they're the best. Or if it's a cost accounting issue, you want to have someone with deep experience in those areas. So you're trying to identify the counsel that you want to use, and of course, before you start that approval process, if you have that type of process, of course, you want to make sure you run all the traps with regard to conflicts and things of that nature. And then also, you should have personal experience with the potential firms that you're going to use, because experience situations where some law firms, when you say the word protest, all of a sudden you get one partner and you get 3 or 4 associates lined up to handle this protest without regard to the size of the protest, without regard to the issues in the protest. And then you have other firms where you reach out to potential protest, and the partner is doing all of the screening and assisting with that effort, and then maybe they've identified that one associate that has experience, with these types of protests. So it may be a higher rate per hour for the latter type of situation, but you're getting more efficiency because that person is more in tune to your concerns about costs. But again, in general, there's a variety of factors, and I think in this situation it really helps to have either personal experience with the outside counsel you're going to choose, or as Devin mentioned earlier, how do we select Devin to use for protests before? And in that situation, again, you're going on recommendations from colleagues who had experience with how that particular attorney manages the protest, whether that attorney was very responsive. And then also, as I mentioned before, when you're going through these various phases of bid protest, post-award grief, it really comes into place in some situations, aside from the legal arguments, it's the temperament of outside counsel. We have outside counsel who, it's kind of the wise professor of bid protest.
That's not me, by the way.
to be able to kind of tell those people who don't like to hear no, that maybe you shouldn't go forward with a protest. And then you have some of the other attorneys. I think Devin, for example, is very good at kind of jumping in and showing everyone on the call that they're in tune to all the different concerns, very knowledgeable about it, and are going to address all of the concerns while putting together a high quality product. But again, that comes from either personal experience with the outside counsel, recommendations from your trusted colleagues, and then in some situation, again, since we ran through this whole spin-off and merger thing with SAIC and Leidos in the previous presentation, sometimes that advice and guidance can come from your former colleagues who are with one of the your previous firms. So again, it's we do that here in the DC area. We're a close-knit community, and I think reputation goes a long way. Not just reputation in general, but reputation within your company in particular.
Courtney, I have a question about the budget analysis, because you're talking about the various approvals you need in order to move forward. Do you work closely with your CFO's office? What is your role as in-house counsel in presenting the budget for the protest, the budget for those costs?
So one of the things with regard to the costs, it's with regard to bid protests, just like other types of litigation, they're generally given a broad range of potential costs because, as Devin mentioned before, you have various exit points during the process that you can actually pull the plug on a protest and not incur additional costs. And then also there are various unforeseen situations that may drive up costs. So for example, if you're going through the protest and you have additional protest grounds after you receive the agency report, and then in some situations it may go to hearings, and depending on the nature of the protest, if you have to bring in experts and things of that nature, that could drive up the cost as well. So I think at least initially is kind of managing the expectations with regard to a range of the potential costs. And a lot of that in terms of the financial side is a discussion among the business folks more than it is the lawyer in those situations.
Okay, so you'll maybe be called into a meeting every couple of weeks, say, hey, we're spending up to here, we're getting ready to pull the plug if we don't see progress, or that type of situation?
I think my situation may be a bit different than other in-house counsel's experience because my experience has been pretty much larger companies, SAIC and Leidos, and I think because the experience with protest matters, you don't have kind of the oversight, I would think, that you might have in smaller companies that are a lot more
so there's more tolerance. There's more tolerance and knowledge and understanding that, hey, this is kind of how it works because of the level of experience, whereas at a company of my size, it might be a little bit different.
Yes.
I'm going to ask 2 more questions on this, but first I'm going to let...
I just had a quick question for Courtney. Do you all ever do in-house protests?
So generally the problem with in-house protests, it relates to the protective order. Generally under the protective order, if you're involved in any type of competitive decision-making, you're going to be easily challenged and you're not going to be... And it's kind of interesting. I I think I was in-house for maybe 1 month, and a protest matter came up, and it just, there was no way that I was going to get in under the protective order. And we're not, a large enough company. I think before, I recall that Lockheed used to have a guy that was kind of firewalled off from the rest of the company that used to do bid protest work, but I'm not aware of a situation in our company where someone has been admitted under the protective order.
Yeah, so for the benefit of the web audience, the question was as to whether you can handle bid protests internally and whether that's done very often. I think we'll see later in the presentation there are some challenges to that.
I will say that recently I was in a protest against Northrop Grumman, and they had in-house counsel be admitted under the protective order. There were a lot of questions that were asked because I was representing the protester, but they, they did an affidavit showing that they're in a different office, that the General Counsel, department was fairly large, and they made a credible case that this particular individual was not involved. It's not common, but I have seen it in my career. I'm going to go to cost two more things. One is, Courtney, have you experienced fixed price, offers from lawyers? And I don't know whether it was when I was representing SCIC or Leidos, but I actually did 1 or 2 protests on a fixed price basis. Very dangerous, I will say, and there were a number of caveats, and in some ways it was a lost leader, but so, it was worth it for us. But how often do you see that? And secondly, I know that you and I sort of talked about, on occasion, you receive a bill and your eyes, sort of bug out, like, how could this have cost so much? What happened there? Is there some way to avoid that?
So I think with regard to taking those in order, with regard to fixed price, one of the reasons why I'm generally skeptical of fixed price arrangements with bid protests, depending on the matter. Again, there are a lot of variables in bid protests. And so it's a type of thing where I want our outside counsel to be motivated to put their best foot forward for the company and not to be focused on whether or not they're losing their shirt because they bid at a price that's too low for what the type of work that they're doing. So generally, I'm skeptical of those types of arrangements. However, we've had situations, and I think it might be one of the ones that Devin's mentioning, where it was a smaller award. The award didn't have significant strategic value for the company, and it was a situation where I was using counsel that I hadn't used before, and I think at that time that we were just trying to go beyond our current stable of protest attorneys. And in that situation, the fixed price wasn't the driver. The idea was that, hey, here's a way to get really high quality representation at a really good price too. And so in that situation, I think it was more the bang for the buck than it was the fixed price arrangement in that situation. And then also with regard to the second part about sticker shock, I think that has happened. I think anyone who is in this business has had those types of situations. But I think as time goes by, as you become more experienced as in-house counsel, you understand that you do have a role, and I think we talked about this before with regard to the extent of company participation. It's really important when you screen outside counsel that you kind of understand the size of the team that's going to be supporting the effort, and that also you're in communication with outside counsel with regard to other activities that may drive costs. For example, we've been in protest situations where an amazing amount of documents were requested from the agency, and then so you're in that situation, well, okay, that's going to be a lot of money that's spent on reviewing those documents. And obviously, you have different ways to address that, whether you're using contract attorneys, firm attorneys, and things of that nature. But I think the way to avoid that situation is, again, working with a firm that you could trust in terms of managing costs, and then also as you're going through, as some of these various unforeseen situations come up, that outside counsel understands that you're going to have a role in that, and that to the extent that you can, that you're involved in the decision-making process. Using the example that I just had there, if there was some sort of document review, making sure that you're doing it in the most cost-effective way so that we can avoid that sticker shock. And then also, if there are going to be various activities that go on during the process, that may affect the ultimate cost. Those are the types of things where not just dealing with outside counsel, it's important for in-house counsel to reach back to the business folks, to reach back to them, to let them know that maybe that cost estimate that you gave before is going to be a little bit lower because of these unforeseen circumstances. And I think that not only just helps you manage costs, but it also strengthens your credibility with your internal clients, because you're basically, you're keeping them in the loop, you're keeping them informed as to why different costs are coming up. And so at least that way, aside from the anger of not winning the award, they're not focusing their anger on you for costing them a lot of money to try to resolve that.
Now, obviously, another question is, well, how likely are we going to win this protest? And you're going to give the answer that everybody hates from attorneys, and the answer is it depends. And truly, it does depend. It depends what form you file the protest. It depends on how many allegations you have. It depends primarily on how you define success. Typically, protests are filed for a couple of reasons. One is they want the contract award. By the way, they're not going to get it. Secondly, they want a second bite at the apple. Well, that's probably the best you're going to get. Or they want more information. The debriefing is skeletal. They don't really understand what's happened, and they just want more information. So those are generally the motivating factors, and success is whether or not you achieve that goal. And as we talked about the protests or the forums, it's a balancing act. There are some considerations that balance costs. At the agency, you're not going to get any discovery or any documents. If you're at the GAO, you're going to get the record, but probably not much more than that. At the Court of Federal Claims, you'll get the record, and there's some opportunities to supplement the record. At GAO, you may have a hearing, but which would be additional evidence. But actually, in fiscal year 2017, GAO conducted hearings in only 1.7% of cases. So you're not going to really count on that. There's the seek a stay, whether you want to try to go and go into the Court of Federal Claims and try to win on the standard there, which is a 4-prong standard, which is fairly high, or whether you're going to go to GAO and get that automatic stay. There also is the remedy. You may get a second bite of the apple, but there may be different ways that second bite of the apple is going to be provided. As we said earlier, the GAO offers a recommendation, which an agency is not going to follow or doesn't have to follow. The Court of Federal Claims will issue an injunctive order, which is binding on the agency. Type of procurement. An LPTA is really fairly hard to protest because you're either technically acceptable or you're not, and it's a fixed price. So it's not fertile ground to come up with protest counts, although I have done it. But it's not the best situation for a successful protest. On the other hand, best value, you've got a continuum, you've got a trade-off analysis, you've got past performance, you may have price realism, cost realism, you have technical evaluation, you have different weighting. There are a lot of areas that you can focus on in terms of a protest there. It does depend on the agency sometimes. In the more substantive documents that I distributed, I list sustain rates for various agencies. And in DOD, they run about 18%. Whereas if you go down to Homeland Security, their sustain rate is only about 8%. So, I don't think that that's a hard and fast rule, but that gives you a sense. Let me tell you, if you're filing a protest at AID or Veterans Affairs, you got a good chance. They're not very procurement savvy. But DOD, the Air Force, they know what they're doing. So that's a consideration. And again, the remedies are important. And in terms of statistics, people love to focus on this. And there are statistics with regard to government accountability protests. And there are two ways to look at them. You have to look at decisions, sustained decisions, where the GAO is agreed with the protester, and something called the effectiveness rate. The effectiveness rate is when protests are resolved. And that could be through a sustained decision, but more often than not, that is when the agency decides to take corrective action. They've had a lawyer look at it, they've said, something's wrong here, we're not going to go ahead and defend this, we're going to take corrective action and we're going to dismiss. With regard to these two percentages, in fiscal year 2017, there were about 2,600 protests filed, which, by the way, was down 7% from the prior year. That also was a percentage increase from fiscal year 2014 through 16. Now, the sustain rate was 17%, which, by the way, was down from 29% the year before. So it has been as low as 12% and as high as 23%. No, I'm sorry, it looked like 29 because I don't have my glasses on, but it's really 23. Now, the effectiveness rate has been, in fiscal year 2017, 47%. It has been as low as 43 and as high as 47, so it's a little bit more static there. So depending on how you look at it, people typically say, oh, there's only about a 20% chance of winning a protest. Well, that's true for those protests that go to a decision. But in terms of those protests filed, you're getting close to 50% of those being resolved, typically in your favor. So that really changes the dynamic in terms of how you understand it. And the nature of allegations are important. I sort of group them in two groups. One group is, what are the easiest allegations to make that will survive a motion to dismiss? I think lack of meaningful discussions, although those, that isn't popular in terms of sustain rate, I think it's very easy to make. If they say to you, we didn't like you because of X, and they never mention X to you during discussions, that's a problem, and that's pretty easy to determine. There are also, technical evaluations. You know more about your proposal than they do, so you generally could come up with an argument to say that they read it wrong. The GAO report for fiscal year 2017, they list the allegations in terms of success. And after you get the report, the analysis is a little bit different. The most popular and most successful allegations are that there was an unreasonable technical evaluation. The second is that there was an unreasonable past performance evaluation. The third is that there was an unreasonable cost or price evaluation. The fourth is that there was an inadequate documentation of the record and a flawed source selection decision. And of course, those latter two are only going to be able to be made, really, once you see the record, but particularly with documentation. But a flawed source selection is fairly easy to make, because if they've screwed up on the prior ones, then the source selection is going to be off, just by the nature of what a source selection is. So all these factors come into play when you have to answer the question is, how likely are we going to win this protest? And then there are numerous other issues that need to be taken into account. I think Courtney has already addressed some of them, and he mentioned internal politics and other issues. I think what the agency often talks about is, oh, well, they're filing only because they're incumbent. Courtney, how often does that really happen?
Well, I think, again, can't speak for all the companies in the industry. Of course that happens, because you just, in that situation, you do the math. If you're a company, you have a contract, and say, for example, you're earning $10 million per month on that particular contract, and you lose, you could see how someone could look at that and say it's in our best interest to extend that out for as long as possible, because you get the additional revenue. But again, I think in larger companies, I think they don't focus solely on the continued revenue stream. I think they look at the ongoing relationship with the customer agency, because you could see a situation where you have a long-term relationship and it's a high-quality relationship where you expect to be able to get additional work from that agency. You don't want to be in a situation where the agency is upset that you protested just so that you can get the additional revenue. In some situations, depending on the amount, that may be the overriding concern with regard to whether or not you're going to protest, because I think it's okay if you step in with valid protest grounds, but companies are generally leery at times of coming in with something that's going to have a longer-term adverse impact on its customer relationship than that short-term gain in earnings.
I'm going to circle back to why incumbency is a factor, just for those people who don't realize how that comes into play. If you get a seek a stay and the agency can't go forward with the contract that they have awarded, that work has to continue to be done. And in most contracts, you have a base period and then you have option years, and then there's a FAR clause that allows the agency to extend that base period or the option year period for an additional 6 months at the same term. And that's typically what's used to cover a protest situation. If you've already used that for other reasons, the agency can award a bridge contract that typically is going to go to the incumbent because of the ease of transition, they're on site, et cetera. So if the seek a stay has been lodged, then you are likely to continue to work for a period of time. Now, how long? Well, that depends. If you file at the agency, they're supposed to render a decision within 35 days. Do they do that? Yeah, not so much. But it's not going to be the 100 days that GAO has to issue a decision. However, the statistics are that nearly half of GAO protests are decided within 30 days, and that goes back to the effectiveness rate, because if an agency decides to take corrective action before an agency report is filed, they don't have to pay the cost. So, and that's the time that they're collecting information for the record, so that's when they tend to make the decision whether or not they're going to pull. So, you may not have that 100 days. Also, there's a statistic that actually most GAO protests, as many as 70%, are decided within 60 days. So again, you may not have the 3 months that you think you're going to have. There's no time limit for resolution of Court of Federal Claims protests, but more statistics. They say that 75% are resolved within 150 days. So if incumbency is an issue, take those sort of things into account. You mentioned customer relations, Courtney, and you touched on internal politics. I list here a number of constituencies that I call within a company, and we discussed about how those can be different. The interest of the different constituencies may be different, and so when you're talking with these different constituencies, sometimes on the same call, what should you be sensitive to?
Well, so one of the things, especially as I mentioned before, you have those 3 elements. I think one part was the intake process, the screening process, and the outside counsel. During that screening process, as the managing attorney, you should try to have that call, you being kind of the senior legal person on that particular call, so that you can screen through and basically sift through and identify what the real issues are before you get involved, the General Counsel or the CEO, because understanding at the business level, they're focused on that particular project, the revenue that they were expecting for that particular project. I think the General Counsel usually is looking at the bigger picture in terms of our credibility before the specific tribunal, our credibility not only our company, but the counsel we use for different types of protests. And of course, most CEOs are locked in on 2 primary things. One is kind of, why do we lose this in the first place? And then the second thing is usually focused on how are we going to control the costs. So it's obviously all are focused on the benefit of the enterprise, but I think when you get to those different levels, you're dealing with kind of a different focus than what you're dealing with at the business level. And then I think on some of those things, sometimes you have to do a little bit of additional legwork. You could be on that initial screening call, and everyone on that call is saying, let's move forward to protest. We've got a valid basis for protest. And sometimes it's that separate call with maybe a key decision maker in that link where you tell that person, I hear all the noise there, but this may not fly. And so you're kind of enrolled as obviously the trusted legal advisor, but when you understand the various politics and the various potential outcomes, you'll want to make sure that before, in my view at least, before you get to the General Counsel and the C-suite, that you basically manage the expectations of management involved, so that they're, you won't want someone going up to the CEO, for example, and all of a sudden they hit just a complete wall where the CEO maybe not interested at all or hasn't been, been at least gotten some background information. So it's understanding the politics, doing what you can to make sure that you resolve what I'll call the minor issues before it goes to the C-suite, and then that way making sure that the C-suite decision makers are getting accurate information, objective information about potential outcomes, and then also at least you are presenting various concerns that the business level has.
I'll say that internal politics also affect outside counsel. With regard to when I represent a company, my client is the company, but really it's the general counsel or the lawyer I'm working with. I want to make sure that they are getting the service that they are expecting, and also make sure that they're not embarrassed with their client, that they are up to speed on everything they need to know. However, I'm often included on calls that include all these actors, and sometimes I don't know who they are. I'll just get these names, but I don't know whether somebody's from the business development or whether somebody's management or somebody is the business lead. Those different agendas are important because it tells me what I need to be sensitive to when somebody is speaking. And to understand on that particular call that there are a lot of different interests that have to be balanced. So I certainly appreciate when in-house counsel says to me, we're going to be on this call, these are the sort of things these people are going to want to know, and by this way, we're going to have the person who wrote the technical, he's really fired up, he really thinks it's wrong, and so I can make sure that I don't put my foot in my mouth, that sometimes happens. But the general counsel or the in-house lawyer can help with that and make it a sort of seamless approach that is sensitive to all these various constituencies.
And one thing with that, it's with that idea that the outside counsel is supporting the general counsel of the company, you have situations where you reach out to outside counsel and they just want to run with the protest. But I think it adds value to the relationship with outside counsel if outside counsel is willing to push back.
Right.
And to be able to say to the general counsel, the CEO, I don't think you should protest here. Again, that gains credibility there because you have some organizations that are just willing to, they'll run. They know that you're going to, your chances of winning are very low. But again, I think it just adds credibility to outside counsel to be able to say to your client, I don't think you should move forward, and here's the reason why, and to be able to stand with that. And I think that you'll find that that type of, I don't really look at it as bad news, but that type of advice goes a long way with regard to credibility.
And I will say that my approach tends to be very candid. I am very willing to be the bad cop. It's my reputation too. I hate filing protests that have no grounds. I hate writing them. I hate arguing them. I'm very busy, and I don't really want to file protests that aren't going to go anywhere. And I don't feel it's in anybody's interest, because if they're not going to go anywhere, then we're going to lose, and the client's going to blame me. So I see nothing good about filing a useless protest, although that sometimes there are temperaments. And in which case, I try to be very candid with the in-house counsel, so they are very candid with their various constituencies, and realize that sometimes you have to go ahead and make the best of it. But it's not something that outside counsel, at least in my experience, like to do, because they have issues too. There are protective order issues that you might want to advise your client about. The in-house counsel is not likely going to participate in the protest, and they're not going to get the other company's proposal. They're not going to hear very much about it, and that's going to be frustrating. So I think in-house counsel needs to prepare the business people for that eventuality. On the last slide, this doesn't really come into a lot of the questions, but I wanted to just highlight some new things that have been going on. You may have heard about the RAND study, which was a study that was done on DoD acquisitions and protests. There were a lot of interesting findings, one of which was that protests are very uncommon, actually. Overrides only 1.4%. Only 3% of DoD contracts are protested. 0.2025% of our COFC protests. So there's some interesting information in there. GAO has now done a tracking system to file protests, and there's a filing fee. And there are two things going on that you may have heard of. DoD is now doing enhanced debriefing, and they're going to do a pilot program, which might be a lead of some concern, where large contractors have to pay DoD for their costs in defending a protest when they lose. That's going to start, I think, in 2019. So to wrap up, oops, gosh, now I've done it. Oh, Lord. Well, you know, the last slide, you know, the things you need to know. Timing is everything. Know the various things that are going to come up. Cost is a huge factor. And have your outside counsel's number on speed dial. And conveniently, my number is on the last slide. Thank you very much. I hope that you at least leave here with one important fact that you didn't know before.
We did have one basic question on allowability of costs. We have a couple of minutes we can go over. Because the question, for example, I get from my CEO is, oh, this is going to cause our G&A rate to skyrocket. And I said, well, not necessarily. Could you talk a little bit about that?
It depends. Generally, they're not allowable in terms of a cost accounting aspect, but there are opportunities to get reimbursed for those costs. If you're a large business, you're not going to get reimbursed at the actual rate, typically. It's traditionally been capped at $150. You might be able to prove that there's a cost of living advancement. If you're a small business, you get everything. So that's good. In the Court of Federal Claims, you don't. Neither party gets costs, but small businesses can go under the Equal Access to Justice Act. So there are various opportunities to get reimbursement. Generally, for large businesses, you're not going to get the full reimbursement.
Okay. All right, well, at this point, we must conclude the session. On behalf of our chapter, we'd like to extend a special thanks to our sponsor, Proprietary Law PLLC, and to our panelists, Devin Hewitt and Courtney Edmonds. Thank you for joining us today. Web participants will receive an email later this afternoon from Beth McConnell with our Virginia MCLE form for this program. Thank you for your participation in today's seminar.